All right, so you're running a website, right? Maybe an app for your business. But here's a question you probably haven't thought about too much lately. Are your terms and conditions actually up to snuff? Are they really protecting you the way you think they are?
That is the $1,000,000 question. And a lot of business owners just, they don't really think about it. And today we are going deep on why these kind of boring sounding documents, your terms and conditions, are so crucial to get right. This is your crash course in why a generic template just won't cut it and what a seriously strong set of T&Cs actually looks like, all thanks to the insights from the folks over at Rick Law Firm.
Exactly. And in this deep dive, we are going to go way beyond just scratching the surface. We're going to break down why using the same T&Cs for every business is so risky, what the really essential parts of solid T&Cs are, and the big decision between going to court or arbitration if you end up in a dispute. Oh, and the kind of surprising dangers of using those automated T&C generators. And of course, we'll get into why having a lawyer help you out is actually a smart move, not just another expense. So first things first, something I've always wondered, why can't a business just grab one of those templates they find online and call it a day? It seems like so many people do that.
Well, think about it like this. Every business is unique, right? You have your own business model. You have specific rules for your industry. You have particular risks you face. It's all different. And generic terms and conditions, they're kind of like trying to fit into a suit off the rack.
Mm-hmm.
It rarely fits your business perfectly right. And that leaves some important areas exposed and could even create some unnecessary legal baggage. Creighton Law Firm makes a great point. A lawyer is like a tailor making T&Cs that are custom fit just for you.
Oh, I love that analogy. That really makes it click. So it's not just about having something that looks official. It's got to be tailored for what your business is actually doing. Can you give us some real-life examples of when that becomes super important?
Yeah, for sure. So picture a business that has a really complex setup. Maybe they have different levels of subscriptions, each with its own features, or maybe they handle really sensitive personal information that needs extra protection. Those generic T&Cs, they just won't have the specific clauses needed to deal with all that. Mm-hmm. And then there are businesses in industries with tons of regulations, like healthcare. You've got Hypay to worry about. Finance, that's GLBA territory. Those standard templates probably won't address those legal requirements properly, and that could mean big penalties. And don't forget about businesses that operate internationally. If you have users all over the world, each country has its own laws, and your T&Cs have to consider all those different legal systems to really work globally.
So the more complex your business, the more you need those bespoke T&Cs.
Got it. Okay, so let's say a business owner gets that they realize a template isn't going to cut it. What are some of those must-have building blocks that should be in their terms and conditions to actually protect them?
Well-written T&Cs, they're like a shield for your business and a clear set of rules for your users. Rick Law Firm points out a few key parts. First up, you've got the limitation of liability clause. Think of this as a way to manage your financial risk. It sets limits on how much users can claim in damages from your business. It's not about avoiding responsibility. It's about being responsible and managing those potential financial risks.
That makes a lot of sense. Setting some boundaries. What other crucial clauses should be in there? If your platform has anything where users are creating content like forums, reviews, comments, you absolutely need a strong user code of conduct. This lays out the rules of the road for how users are expected to behave. It helps you keep things safe and positive and gives you a way to deal with bad behavior. And then there's one that sounds kind of technical, but it's so important. The governing law clause. Imagine you have a dispute with a user on the other side of the world. This clause says which country's laws will be used to sort it out. It prevents a whole lot of legal confusion.
Okay, so that simplifies things a lot if you have international users. What other key protections should businesses think about?
You definitely need an intellectual property protection clause. This one protects your valuable stuff, like your trademarks, logos, copyrighted material, so no one can use them without your permission. Then there's the dispute resolution clause, which we'll dig into more in a bit. But this one lays out how you've agreed to handle disagreements. Will it be through the court system, a process called arbitration, or maybe mediation? And lastly, don't forget a termination clause. This gives you the right to suspend or even close a user's account if they break your rules.
It sounds like those are all essential parts of a really strong set of terms and conditions. Now, you mentioned that dispute resolution clause in choosing between litigation and arbitration. It's like a fork in the road. Can you break down the main differences between them and the pros and cons of each path?
Yeah, this is where things get really interesting because this choice has a big impact on how disputes actually get handled. Rick Law Firm gives a helpful comparison. So litigation, which means going through the courts. That can be a long and winding road. It can take years to reach a resolution, and it tends to be pretty expensive because you've got court fees and legal fees that just keep adding up. But a key aspect of litigation is that it's transparent. The proceedings are usually public record, and importantly, there's the possibility of appeal if one side doesn't agree with the decision.
So the plus side is that potential for appeal and public accountability, but the big downsides are time and money. How about the alternative arbitration? What's that all about?
Arbitration is usually a lot faster, and it can potentially be cheaper than a full-blown lawsuit, although the fees can vary. A big difference is that arbitration is usually private. It happens outside of a public courtroom. However, the decisions made by the arbitrator are usually binding, meaning there's very little chance for an appeal.
Okay, so it sounds like arbitration offers speed and finality, while litigation gives you the chance for an appeal and public proceedings, but it takes more time and money. Are there any other less obvious things businesses should be thinking about when making this decision for their T&Cs?
Definitely. Very law firm points out that sometimes the bar for demanding arbitration can be lower than for filing a lawsuit, which could be something strategic for a business to consider. Also, depending on the details of the arbitration agreement, the business might actually have to cover some of those initial arbitration costs. Whereas in litigation, the person bringing the suit, the plaintiff, usually pays those upfront expenses. And it's good to know that there are well-established arbitration organizations like the American Arbitration Association, AAA, and JMS. Businesses can actually specify one of these in their T&Cs to handle the whole arbitration process.
Wow, that's really helpful for understanding that decision. Now let's switch gears completely and talk about those automated terms and conditions generators that are everywhere these days. They make it seem so easy and cheap. What are the hidden dangers of using those seemingly convenient tools?
Yeah, it's tempting, right? They're fast and cheap. But relying on them to be your only source for T&Cs can be risky business. Like Rich Law Firm highlights, these tools tend to spit out really generic clauses. They don't understand the ins and outs of your business and the specific legal landscape you're dealing with, so they often won't give you enough protection.
So it's like a one-size-fits-all approach, which we know rarely fits any business perfectly.
Exactly. And on top of that, the legal world is constantly changing. These generators might not get updated with the latest laws like GDPR or CCPA, which have a huge impact on how businesses handle user data. You could be hit with serious fines if you're not compliant. And they just can't provide the customization needed to address all the specifics of your business model or the unique risks in your industry.
Right, because laws are always changing and every business is different. What other downsides are there to using these automated shortcuts?
Another big one that people often overlook is how you actually get users to agree to your terms. A lawyer plays a crucial role in setting up what's called a consent architecture. Basically, it's the process and the way you get and document a user's agreement to be legally bound by your T&Cs. Even the most well-written terms are useless if a user hasn't properly agreed to them legally. Think about those little checkboxes you click online. There's a whole legal method behind that. And Rich Law Firm also points out the important connection between your terms and conditions and your privacy policy. These two documents need to work together, and automated generators might not make sure they're compatible. That could create contradictions or gaps in your legal protection. So basically, while these tools might seem convenient, they just don't have the human expertise and legal knowledge to really make sure you're compliant and protected from potential risks.
So trying to save some money up front with an automated generator could end up costing you a lot more down the line if you run into legal trouble. Which brings us to the real value proposition here. Hiring a lawyer to draft your terms and conditions. What concrete benefits does an expert bring to the table?
The advantages of having a lawyer on your side for T&Cs are huge, and there are lots of them. As Reese Law Firm says, lawyers provide tailored protection. They take the time to really understand your business, how it works, your specific risks, and your long-term goals. Then they create T&Cs that actually address those needs. No generic clauses that might not protect you enough or could even create unintended liabilities.
So it's much more strategic and personalized approach.
Yeah.
What other key benefits do they provide?
One of the most important is ensuring legal compliance. Lawyers are up to date on all the relevant laws and regulations, local, state, national, even international, that apply to your industry. That is so important for avoiding legal headaches and making sure your business is operating within the law. They also offer really valuable risk mitigation. Because they have experience, they can see potential areas where disputes might arise, and they can put specific provisions in your T&Cs to minimize your risk if those disagreements happen.
It's like having a legal safety net custom built for your business.
Exactly. And that safety net is built to be enforceable. Lawyers use clear, precise, and legally sound language when they draft your terms. It's designed to hold up in court if a dispute ever escalates to that level. And finally, while it might seem like a big investment up front, hiring a lawyer to create your T&Cs can actually save you money in the long run. By tackling potential risks head-on and making sure you're compliant from the get-go, you're way less likely to face expensive and time-consuming lawsuits down the road.
So the takeaway here is that a lawyer's role in crafting terms and conditions goes way beyond just writing legal stuff. They're like a strategic advisor who really gets your business and builds a legal foundation to protect you now and in the future. They're not just drafting a document, they're building legal security.
Couldn't have said it better myself. Those automated shortcuts might seem like a quick fix, but they just can't match the deep understanding, strategic thinking, and legal expertise that a qualified lawyer brings to the table. Investing in custom-drafted T&Cs is an investment in your business's long-term stability, security, and ultimately, its success.
This has been eye-opening for sure. So thinking about everything we've talked about today, what are some things our listeners should be looking at in their current terms and conditions? What should they be asking themselves? What red flags should they be looking for?
Great question, and one everyone listening should be asking themselves. First, look closely at whether your current T&Cs really reflect how your business actually works. Did you just plug in some generic stuff, or did you tailor them to your specific operations? Second, do they specifically address the regulations in your industry? Are you sure you're covered for things like data privacy or accessibility? And finally, have you really thought about your dispute resolution clause? Do you understand the pros and cons of litigation versus arbitration for your business and the kinds of disputes you might face? The bottom line is your legal documents aren't set in stone. They need to change as your business grows and as the laws change. Taking that proactive step to review your T&Cs with a legal professional can give you incredible clarity, peace of mind, and rock-solid protection for your online presence.
I think that's some solid advice to end on. Really appreciate you walking us through all of that. Until next time, everybody.
Absolutely. It's been a pleasure.